company law perspective and topics that are interesting to look at from a comparative perspective. And maybe picking up where we left yesterday, maybe there's a thesis topic that one of you or some of you might find interesting to think about it a little bit. Okay, we start easy, talking about loans today, debt financing. One difference between the common law jurisdictions, UK and US, is that, and Germany on the other hand, is that loans in these common law countries are exclusively governed by the individual loan agreement, at least as far as commercial loans are concerned, which means what you don't have in your agreement is not there. If you're not careful, tough luck. Whereas in Germany, you have provisions on loans in the civil code that give you some fallback rules. If you haven't thought about, for example, the right to terminate the loan if the financial status or financial state of the borrower deteriorates, there is an extraordinary right to terminate in the code. So there are some provisions. And even more important, in our civil code, we have provisions on standard contract terms, general business terms. If they are drawn up by one party and imposed on the other parties, sort of on a take it or leave it basis, there are limits. First of all, there are requirements how you have to disclose these terms so that the other party can take notice of them. If you don't disclose them properly, they don't become part of the contract. There are rules of interpretation. If these terms are ambiguous, then they are interpreted in the way that is most favorable for the other party. So you can leave them vague and then hope, a court will interpret them in your favor. They won't. And then there are specific provisions that explicitly say some typical terms that are perceived to be unfair are void. And even though these rules on general business terms or standard contract terms were mainly introduced to protect consumers, the weaker party, sometime in the 1920s and 30s in Germany, they also apply, though in a more relaxed form, to business dealings, even between two companies. Sort of the underlying ideas of these rules apply to business contracts. Which means if you have something blatantly unfair, and we'll look at that in a moment, blatantly unfair in your contract terms, then this will not be enforceable. To give you an example, even though applicable mostly to consumer loans, but to some extent maybe even to business loans, the High Federal Court in Germany has, for, the past 10, 15 years, always decided that the consideration for the lender must be in the form of consideration. And frequently, banks have had all sorts of extra fees, fees for overdrawn accounts. Say, we have to look at, if you overdraw your account, we have to check, and that costs money. All sorts of fees, and they have consistently been struck down by the High Federal Court, saying, well, if you do something as a lender in your own interest, for example, you cannot impose a fee for checking whether and to what extent the customer is creditworthy, because the court says, well, you do that in your own interest. Or because you must, because banking regulation requires you to do so, and you cannot pass on these costs that you incur in your own interests in the form of a fee to the lender, to the borrower. So the only way you can charge is interest, not these different types of fees, which was nice for the banks because, a little bit of fee here, a little bit of fee there, plus the interest, and suddenly you see, oops, quite a bit to pay. No, only interest. And one can argue, and it is argued, whether that makes sense or whether it's not reasonable to say, for example, if I overdraw my account and the bank allows me to take up more money, then I have to pay an extra fee on that because it's extra risk added. But the court has not has not adopted these arguments that have been proposed. So all based on these provisions, standard contract terms, only interest, no, at least in the consumer field, no other types of strange fees or so on, which shows how important this instrument is for the protection of the borrower. By the way, standard contract terms, special rules on the scrutiny of standard contract terms. Why is that? Does that make sense? I mean, the idea that terms are imposed on the other party, I mean, the idea of a contract, isn't that two parties with opposing interests meet, and then they negotiate, and then they strike a compromise that's fair for both, arguably, and because they have agreed to it, there is no reason, unless a party has been coerced or deceived, to second guess whether it's fair or not. I mean, isn't that the whole idea of a contract? I have your interest as a seller to get as much money from you as I can. You as the buyer have the interest to pay as little as you can. I don't want to give you any guarantees that the product is great and viable, and you want all sorts of guarantees. And then we argue, and you give a little bit, I give a little bit, we strike a compromise, and by definition, because we have negotiated and agreed to it, it's fair. If you ask yourself, have you ever in a store negotiated about the terms of the contract? Have you ever negotiated, at least in Germany, I don't know how you do it in your own countries, but have you ever? Do you go to a bakery and they charge you 50 cents for a roll, say, no, you know, I buy 3 rolls, but I want to pay only 40 cents. I mean, you can, sometimes if you buy expensive products, really expensive, then in some stores you can bargain and say, give me a discount. But usually sort of on the warranties and guarantees and all these sorts of things, the payment conditions, usually it's in the standard general business terms. You don't think about it, but if you go to a department store like Kaufhof, somewhere there are general business terms, probably at the cash counter, that you can look at. Or if you go to a bank and open a savings account or your current account, have you negotiated about the terms, about the interest? No, never. It's the term, and you assume the bank has its standard contract terms, its general business terms, and those are the terms of the contract. You don't negotiate. And that's why in real life, at least for everyday contracts, the idea, you know, you strike a bargain is unrealistic. Usually one party, the business partner, sets up the terms, and you take it or leave it, and if you don't like it, you go to some other store. And the same with banks, with loans. If it's a huge loan, a very big loan, of course, then you individually negotiate, but usually you also start from some general business terms, some general contract terms, set up by some bank association or so forth. And that's why, because usually one party draws up the terms and the other has more or less to accept them. That's the idea underlying these provisions on scrutiny and review of standard form contracts. And in Germany, as said, that also applies in a limited extent to commercial contracts, so that when a corporate finance, when a company borrows money from a bank, that protects the customer. And I'll come back to that in a minute. Fixed variable interest, okay, you can charge fixed interest. Usually in longer term contracts, that's not the case. Usually interest is variable, usually tied to some standard interest rate like LIBOR, Euribor, and you heard about the scandals that these reference interest rates have been manipulated, so much for that. But that's usually how it's done, some standard interest rate plus some margin, because that, you know, doesn't expose the lender or the borrower to the risk of receiving too little or paying too much. Are there limits to how much you can charge in a commercial loan in the UK and US? No, unless you coerce someone, put the gun to their head, or unless somebody is insane and incapable of entering into a contract. No, you have to watch out for your own interest. Whereas in Germany, there are, even for the commercial world, some limits. Uncommonly and disproportionately high interest rates may be void. So if you succeed as a bank in charging more than double what the standard interest rate, normal interest rate in that market segment is, that may be void because it's uncommonly and disproportionately high. And interest rate adjustment clauses in a standard form loan, in a general business term of a bank, have to be clear and unambiguous. Otherwise, they don't become part of the contract. So that is one protection for the borrower when the bank imposes its contract terms. And you could, in theory, leave the adjustment of the interest rate to the lender, to the discretion of the lender, and if you do that, then in Germany at least, there are limits to what you can do as a lender. If you don't explicitly agree to that, you can only pass on your refinancing costs to the borrower. So only if your refinancing costs increase, you can pass that on by a discretionary increase of the interest rate, not some other cost. So if you agree with the labor unions that your employees receive 5% more salary, you cannot pass on that to the borrower based on such an interest rate adjustment clause. If you have discretion, only a fair and reasonable exercise of the discretion is valid. If you say my refinancing cost has gone up 1%, so I'll charge you 3% more, that would arguably be not fair and reasonable and therefore invalid. And if you can't do raisin picking. If you have discretion to adjust the interest rate and you use that discretion to pass on higher refinancing costs, you also have to pass on reductions. So you can't get the best of both worlds. And that is also true in a commercial loan. Because otherwise, the adjustment clause would be unfair. Okay, after this general framework, now a topic that is may look quite specific, but from a comparative perspective, it's interesting in several respects, and it's also relevant for all sorts of commercial contracts, including loan contracts, namely the protection of the lender against defaults of the borrower. And frequently, not only in loan contracts, but in other contracts, for example, in construction contracts, you find clauses, take a construction contract where you have a contract with a general or with a large construction company or a conglomerate of construction companies to set up the high-rise building until May 30, 2020. And of course, you want to rent out the premises, lease the premises. You enter into contracts with your tenants so that they can move in June 2020. And those tenants terminate their other loans that they may have. So if they cannot move in by June 2020, then everybody has a problem. I will not receive my rental income. They will have damages because they don't have a place to stay. The old place is already gone. The new place is not ready. And you try to protect yourself against failures of the construction company to finish on time. And one way of doing it is a liquidated damages clause, which is, you jump ahead a little bit, even in the common law countries, completely legal. You can have liquidated damage clauses in your contract. But if you go beyond that and impose a penalty, then in the common law countries, that is invalid. So while liquidated damage clauses are okay, penalty clauses are invalid. The liquidated damages and penalties are just two words. What is a liquidated damage clause?
It's a predefined sum of money which has to be given in case of any default.
Mm-hmm. Okay, so in case of default, you predefine a sum of money that has to be paid either as a lump sum or periodically. So for every month that the building is finished late, you have to pay me 10 million pounds or euros or whatever. Why do I do that? Why do I have such a liquidated damage clause? I mean, if there is damage, then why don't I just go to court and say, you know, the construction company agreed to finish the building by May 31st. It didn't finish by May 31st. Therefore, I have lots of damages. First of all, I don't receive rental income. Secondly, I have to pay my tenants for not being able to provide the premises. And then I have other costs, A, B, and C. So here's my calculation. These are my damages. That's what I want. Simple. Why a liquidated damages clause?
calculation takes a lot of time to apprehend how much money is actually suffered.
Time is one issue, it takes time to calculate, but that's probably not the main issue. The main issue is proving it. You have 25 in a large construction company with 150 tenants, and you say, I have to pay damages to my tenants and I don't receive rental income. Maybe you can say how much rental income you don't receive, but proving that each of these 150 tenants suffers how much damage that he or she can pass on to you takes a lot of time and effort and cost to prove, and it's subject of debate in court, argument, because of course the construction company will deny each and every one of those positions and say, prove it. So it costs a lot of time and money, and liquidated damage clauses are supposed to relieve you of the burden of proving all that stuff. So you make a pre-estimate, if the building is finished late, how much am I likely to suffer for each month, including my refinancing costs, loss of rental income, damages I pay to the tenants, and then at least sort of some damage is already pre-agreed and you don't have to prove it. It makes it much easier because all you have to do is to go to court and say, see, 1 month late, we agreed £10 million for each month. That's what I want. And if you suffer additional damage on top of that, okay, then you can go on and try to prove it, but at least the 10 million is what you get. So that's a legitimate purpose, and that's why liquidated damages clauses are legal and recognized in the common law countries as well. What distinguishes such a liquidated damages clause from a penalty clause?
If it is a genuine pre-estimate of what damages could occur.
And a penalty clause in contrast?
Penalty clause is unreasonable on its face. It does not actually show you what damages could happen.
Okay, and why would you impose a penalty? What would be the purpose of going beyond just sort of making a pre-estimate of what your damage might be? Go beyond that and say, I don't know, I guess I will suffer about 10 million euro per month for each month that the building is finished late. But I want more than that. I want 30 million from you. 30 million for each month that you're late. Even though my estimate is 10 million is the actual damage I would suffer, I want 30 million.
Deterrence. Deterrence in terms of that you don't want him to do this because he knows he's going to suffer a huge sum.
Yeah, so basically to coerce, to force the other party to perform. It's not just that they have to compensate you for your damages, it's sort of an additional incentive. If you don't perform as promised, you will suffer. And that's the incentive. It will be so expensive for you if you don't finish that the incentive to do your very best is very high. And if you don't comply with your contractual obligations, well, I'm sad in a way, but on the other hand, I'm happy. There's a laughing eye as well, because not only will I be compensated for my damages, I'll also make a profit. So main purpose is incentivize, force to perform. And those clauses, for reasons we'll discuss after having looked at the German counter model where damage clauses are actually legal and valid to some extent, those clauses in the common law countries are invalid. Liquidated damages, yes. Penalties, no. And that's why when you look at corporate finance, a loan contract, where there is a clause such as in Lordsville Finance or Cavendish or Garrett here, both loan contract cases, where the bank says for every month, if you default on an installment of paying back your loan, the interest rate goes up, or you have to pay some additional sum of money, an additional fee or whatever. You can think of all sorts of things that a bank can come up with. And these clauses would be valid if they're liquidated damages, invalid if they're penalties. And therefore it's important to know how to distinguish between an illegal penalty and a valid liquidated damages clause. And the classic case is the old Dunlop pneumatic case, which was sort of in the common law countries, at least the Commonwealth countries, the leading case until this 2015 Cavendish Square Holding and Parking Eye Limited double case came along. I gave you a little excerpt, I don't know, 10, 14 pages. The original case is about 140 pages, so I had to read it all. Be happy that you didn't have to. But because it's so important and because it's the current law, that's why I included it. Now, a Cavendish square holding picks basically up where Dunlop left and sort of specifies a little bit more what Dunlop, how Dunlop is understood. But let's start with the Dunlop case. Can one of you brief the case for us? And briefing the case means give us a short summary of the story. What's the story in the case? The second step is what was the issue in the case? Okay, the story, the legal issue. What did the court decide? To give the not to keep the suspense up too long. Tell your audience, okay, that's the outcome, and then give the reasons. So story, facts, legal issue, holding, and reasons. And good exercise for you because if you work as an associate in a law firm or in a bank and you have to, whatever you do, you have usually, when you start, people for whom you work, superiors, and they ask you to summarize a complex set of facts for them and give a proposition, or to summarize a case, so that they have in a very short time an idea of what the law is. And sometimes you may have to do that in a foreign language, English, if you have other colleagues from other countries there who don't speak Mandarin or whatever. You may have to do it in English, and now is good opportunity for you to practice, where nothing can happen if it's not perfect. Can anyone try? Good exercise. Dunlop, simple story. Please.
Dunlop is a tire factory, and his new garage is a tire retailer, and they have the contract. The contract provides that they set a price of every tire. If the retailer sell the tire lower than the provision price, and new garage will pay £5 per tire.
Mm-hmm. Okay, so that's really the story, and of course, otherwise it wouldn't be a case that new garage sold for less than the retail's list price, and had to pay, was sued for £5, and then the question, liquidated damages and penalty. To understand it, and £5 in 1915, that was a lot of money. I mean, it's not like £5 today, where in London you can barely get a hamburger. £5 sterling, that was a lot of money. Maybe the equivalent of today, I don't know, £200, £250, for selling a tire for less than this price. So you ask yourself to understand, I mean, in order to understand, we always said liquidated damages are supposed to relieve you of the burden of specifying individual damage positions and proving them, whereas a penalty clause goes beyond that, tries to incentivize and force and coerce the other party to perform. And in order to understand what this clause in the contract tried to do, we have to ask ourselves what's the purpose of the clause. And my question to you would be, why should the tire producer Dunlop care at what price the retailer sell? At Dunlop, I produce tires, and I sell to the retailers a tire at £1 per tire. And whether they sell that tire for £2 or for £1.30 or for £2.30, that's their business. They make more or less profit. Why should I care how much profit the retailers make as long as they pay me £1 per tire? And if you're looking at it at this, or posing the question like that, would be, if there is no legitimate interest, if there is no possible damage that Dunlop could suffer if a retailer sells at less than this price, then it could probably not be a liquidated damages clause. Because liquidated damage, pre-estimate of a damage, if there is no damage I can suffer, then it cannot be a liquidated damages clause. So in order to understand the case, we have to ask ourselves, why should Dunlop impose list prices for retailers? Why should the producer care?
because there are other retailers
Okay.
with Dunlop.
There are other retailers, and maybe
Yeah.
if New Garage sells at less than the proposed list price, then the other retailers are unhappy and have to lower their prices. So then there will be competition among the retailers, and the prices, the retail prices, will go down because they compete for customers. But why should I care as Dunlop? I sit back and say, well, my price is £1 per tire. And whether you make £1 profit per tire or 1 shilling profit or 1 pence, that's no concern of mine. I don't care.
I guess whether it will have an impact on their market value or their reputation or their brand effect, like the luxury. So I just made a guess.
Okay, sort of luxury tires. Okay, when you go to Hermes and buy a scarf or a bag, you pay for a bag €8,000 because it's Hermes. Probably good quality, but is it worth 8,000? You pay for the image. And of course, part of the brand value is that it's high class, and therefore they never give discounts. They never have. Once a year in Germany, they have a sale in a hotel, either in Hamburg, Munich, or Frankfurt. So watch out for that if you're looking for that. And then they sell some stuff, but not something you can choose. Whatever they have, they sell. But otherwise, unlike other stores, no sales ever, no bargaining for price ever. Be happy that you get it, and don't have to wait for 5 years, only 2 years. But tires, I mean, will you go if you have, I don't know, a friend with a car and say, wow, Dunlop tire, boy, that's a high class guy, or girl or whatever. So tire is sort of not really a luxury product. So I don't know if the purpose is to say, wow, we want to establish Dunlop as a premium tire producer, and we can only do that if Dunlop tires sell at a high price. It's an idea, but I don't know if it's convincing with a tire. It's convincing with luxury products, where actually people buy them because they're expensive. They would be unhappy if they were sold cheaply. But with a tire, I mean, would you be unhappy if you got a discount? Probably not. So other reasons. So I'm now the lawyer for New Garage, and you make the argument as the Dunlop lawyer, that's the purpose, and I say, no, come on, be serious, no way. What? I mean, you said there are other retailers and sort of the price competition. Think it a little bit more, think a step further. So you have all these retailers, and they compete because one garage undercuts the list price, and then the other ones have to go down, and then they go down and down and down. And then they make very little profit on the Dunlop tires because of all that competition. And I said, well, why should Dunlop care? They say, £1 per tire, tough luck. What would you, if you put yourself in the position of the retailers, what would you now do? If you see I make very little profit with the Dunlop tires.
I would change suppliers.
Either I move to another company and say, I don't sell Dunlop anymore.
Or maybe I'll ask for a discount.
Or you go to Dunlop and say, come on guys, we're not making profit on your tires. Give us a discount, go down with your price. And that's why you have this system. Because you want to make sure that by implementing this system, retail system with consistent prices, with the same prices, the retailers make a nice profit and you make a nice profit. You have a bunch of retailers who are happy and will sell your products, and then they will not come to you and ask you to cut your own prices. That's why you have these pricing systems, and that's where the damage for Dunlop is, because if somebody doesn't stick to the retail price, the other ones will be unhappy and say, come on, if they sell for less, I will sell for less. And then the spiral of prices going down, and eventually people either not selling your products or asking you for discounts will have started. That's the danger. And that's where that Dunlop says that's why this is liquidated damages. And the court developed in Dunlop a number of criteria of how to determine that. It starts out easy, says you look at the name of the clause. Does it say liquidated damages or penalty? But I mean, window dressing. You can have a penalty clause that's evidently evidently a penalty clause because it asks way too much. put the label liquidated damages on it, and it's still a penalty clause, right? So if you have a horse and put a label on it, cow, it's still a horse, not a cow. And same with the clause. So the name, unless they are stupid enough to say this is a penalty clause themselves, where you'd say, I'll take you by your word if you yourself say it's a penalty, then it probably is. Unless they're so stupid, the label doesn't really carry very much. Then you already mentioned penalty clause is a genuine pre-estimate of the damage that the party using the clause is likely to suffer in case of breach of contract. Whereas penalty goes beyond that. So you ask yourself, is this a genuine pre-estimate of the damage you are likely to suffer? And the court goes on and says, well, if the damage consists of a sum of money and what you're asking is more than that sum of money, then it's probably a penalty. That's pretty simple. But the problem here in Dunlop, as in Cavendish and Parking Eye, is that it's pretty hard to say in numbers what the damage to the pricing system will be in case of the individual breach. I mean, I can say if in the case of the construction contract, I can pre-estimate the financial damage that I'm likely to suffer if the building is not finished on time. Because I can put a number on my refinancing costs, I can put a number on the foregone rental income, I can probably put a number, estimate at least, on the damage I have to pay to my tenants for not being able to provide the premises. Okay, this is all money. But here, there's a pricing system. Difficult to say what the damage to the pricing system will be. So the court says if it's impossible to give a precise pre-estimate, then that militates in favor of a liquidated damage clause. I mean, you can't really say what the damage to the pricing system will be. You only know that if that happens several times, more than once, then the pricing system eventually will not uphold, and that will cost you money. And you don't even know how much money it will cost you. So it's very difficult to give a precise pre-estimate. So if you can put a number on the damage you're likely to suffer and you go way beyond it, very likely to be a penalty. If it's impossible to give a genuine pre-estimate of the damage, because like in Dunlop, what's the damage to your pricing system? When will the air go out of the balloon? Then sort of more in favor of liquidated damage clause. And jumping a little bit to the US case, the Garrett case, where it was also a loan and Lords of Finance also loans. You had in both cases you had typical loans, which you also find in the commercial world, installment loans, which means the borrower takes a loan of, say, £1 million or $1 million or whatever, and will pay that loan back in installments, means 100 pieces of £10,000 or euro each. I will pay that back over 100 months, and I will pay, 3% interest to take fixed interest. So let's say 1 million loan, take it up, and then over time, here this is 2015, and supposed to be paid back by 22. And so you have every month 10,000, 10K for 10 kilo as the Greek word for 1,000. You have to pay back 10K. And now here say, plus 3% is the interest rate, and here installment 50 there is a default, and in both cases, in Garrett and in Lordsvale, this default triggered an increase in the interest rate, some margin, which means now, let's say, plus 4% suddenly. That's what the loan contract says. And the question is, and that's more to the point in the loan contract scenario that we're talking about, debt finance of companies, than in the Dunlop case. Is that a liquidated damage clause? Is that liquidated damages, this increase of 1%? Or is this a penalty clause? Am I punishing you and trying to motivate you not to default, or am I collecting damages? And as you saw from the cases, if you read them, Lordsvale was in favor of a liquidated damage clause, whereas the Garrett case said, oh wow, this is a penalty clause. And if you think about this increase in interest, I mean, you can, or I can, if I start, think of at least 3 ways in which you could design the clause. And one is clearly a penalty, and one is clearly liquidated damages, even the Garrett court would say that, and one, which we had in both of those cases, is open to argue. The clear damage clause I would propose, a clear penalty case would be if I said, you know, if you default with one installment, you have to pay 4% interest, not only on the future installments, but also on the ones you already have paid back. Which means if I default with installment 99, I have to pay 4% interest suddenly, not only for the last 10,000 euro, but also for the 990,000 that I have paid back. I think clearly a penalty, because what damage could I possibly suffer with regard to money I already received back with interest? So clearly a penalty, and the purpose could only be, you know, force the other party not to default, keep them from defaulting. And the more you have already paid, the higher the cost for you will be if you default. Because the more you have already paid back, and the more additional interest will be due. The other case would be I default with installment 50, and all I have to pay additional interest on is installment 50, because that's the one I'm in default with. Installment 51 is only due next month. I have not defaulted on that. And that's what Garrett says. You know, there is no default on installment 51, 52, and so forth. So therefore, in order for this to work as a liquidated damage clause, you can only ask additional interest on this installment. And everybody would agree this is liquidated damages because I didn't get the money on time, and that's why you have to pay me extra. The case that we had in both of those, or the design we had in both of those cases was no retroactive effect, as Dunlop says. If there is a retroactive effect, meaning I have to pay interest on the installments I already paid back, that is clearly a penalty. But for all installments that are still outstanding, that's the design in Lordsville and in Garrett. You know, once there is default, all the outstanding penalties, you have to pay additional interest on all the outstanding penalties. That means 500,000 you have paid back. You don't only have to pay interest on 1% more on 10,000 euro, but on the whole 500,000 that are still not paid back. And the question is open to debate, as you see, because 2 courts have come up with 2 different outcomes: liquidated damages or penalties. And the argument for penalty, I've already said, there is no default on those. Future 51, 52 until 100, there is no default on those, and therefore if you ask additional interest on installments that are not yet due, clearly this goes beyond any damage you have suffered. Because the only damage you have suffered is you didn't get these 10,000 on time. What's the counter argument? And I think it's very simple. You're all hopefully eventually being, as to the extent that they're lawyers, commercial lawyers advising banks or other institutions on their finance issues. And what would be, they ask you, can we have a clause like that? There is this issue of penalties, is this valid? So you have to give them an argument why it could be, or possibly, most likely would be valid. If you put yourself in the position of the bank, what would you say? Sorry, your colleague back there.
If you already defaulted in one installment, that means that probably means your business is in trouble. So the risk that you will default for the outstanding installments are higher now.
Yeah, absolutely. Of course, you would say commercially, Euribor plus 3% was based on a certain risk assessment, and now you defaulted, and it turns out the risk assessment was too positive. Your risk is higher. And risk, I mean, interest is partly at least compensation for the risk of default. And if the risk of default turns out to be higher than estimated, then that is a damage. I'm compensated for having to bear a higher credit risk than I had anticipated. That would be the counter argument. Absolutely, and I think it's a valid argument. We have now. I just wanted to briefly come back, because that's sort of a reformulation of the Dunlop case and the penalty doctrine, prohibition of penalty doctrine in the UK. The two cases, Cavendish Square Holding and Parking I Limited. Cavendish Square Holding, because the case is sort of complicated and we don't want to spend too much time on it. I'll sort of briefly summarize the facts. So, and they were not all apparent from the excerpt I gave you. Cavendish Square Holding and al-Maqdisi had to do with it's a sort of a marketing and advertising company. Mr. al-Maqdisi was very prominent in the Middle East, I think in Lebanon. He was situated and sort of founded with a partner advertisement and marketing company that was the biggest in the Middle East. That was bought by a subsidiary, Cavendish Square Holding, subsidiary of the largest advertisement company or group in the world. And of course, what you pay is not just the office space and the interior. What you pay for is the connections, the goodwill, right? Because marketing advertisement lives off the goodwill of the people who do it. I mean, not of the office space, not whether you have nice furniture and nice IT. That's all okay, worth something, but really the brain power and the connections behind it, that's important, that you have the customers. That's why they said, we're paying you something, a considerable amount. We could retain you as a consultant because we want to use your connections, and you may not compete with your company. You may not set up another advertisement company using your connections that you have for that business and taking them away from our business that we bought. If you do that, if you violate that covenant not to compete, we will buy the rest of your shares that we have not bought at a lower price, only at sort of nominal value or asset value, and we will not pay you for any goodwill. And the outstanding, whatever we owe you, is also discounted. So all in all, Mr. al-Maqdisi, who violated that agreement and started to compete and set up another advertisement company in the same area, and take away business from his old company that was now owned by Cavendish Square Holding, sort of was punished, in quotation marks, by a reduction of the purchase price of about £100 million, sort of a considerable amount. And of course he said this is a penalty. And Parking Unlimited is a shopping center in some English town where you had parking spaces that were operated by this sort of outsourced to Parking Unlimited, not by the stores or the operator of the shopping mall, but by some specialized company that runs parking space, or so those parking spaces, and the conditions were you can park there for 2 hours free. If you park for more than 2 hours, you have to pay £80 penalty, or you have to pay £80 additional fee for or fee for parking. The reason, very simple. There were also apartments close by, and you didn't want people who visited or who lived in the apartment or who visited to use the parking space to visit friends or to live in their apartments and park their cars and take away the parking space from the customers of the shopping mall, because the whole idea is people can go park very simply. They don't have to carry their goods a long way and use public transport. They just go to the parking spot, put them in the trunk, and go away. And if all the parking spots are taken by people who live in the apartments or who visit, that doesn't work. Again, and Mr. Beavis parked half an hour longer than 2 hours or something like that and was charged £80 and said, excessive, that's a penalty. And in both these cases, one in a commercial setting, one in a sort of private setting, the question was, again, penalty versus liquidated damages. And the court, here the English Supreme Court, former House of Lords, now called Supreme Court, took a more liberal view maybe than anticipated when you looked at Dunlop and Lloydsville in these cases, and said, you know, as long as you are compensated for a legitimate commercial interest, and this is not clearly in excess of any damage you might suffer, this qualifies as a liquidated damages clause. In Cavendish, they said, you know, what you're discounting the purchase price for is the loss of goodwill. And that's legitimate because your interest, you pay such a high amount of money to Mr. El-Makdisi for his company shares, not because he has valuable and nice office space or interior, but because of his connections, the goodwill. And if that goodwill is gone because he competes, then it's basically worthless. And therefore, legitimate pre-estimate of damage, this is liquidated damages. And Parking I Limited, same thing. The whole business model works only if the parking spots are available for customers of the shopping mall. If you don't make sure that the parking space is not taken up by people who don't shop, but who go and visit the apartments or live in the apartments, the whole business model of the shopping mall won't work. And therefore, the damage, even though you can't put a number on what damage exactly will you suffer if one person parks 10 minutes more or half an hour more. Just as in Dunlop, difficult to say what's the damage for the pricing system. But what you can say is that if you allow this to happen, not just infrequently, the whole business model won't work. The pricing system in Dunlop won't work and the shopping mall won't work. And therefore, the damage you're likely to suffer if your parking spots are taken out by other people, or if your list prices are undercut, the damage is substantial, and therefore this is a genuine pre-estimate of liquidated damages where it's hard to put a number on. It's impossible to give a precise pre-estimate of how much damage exactly you will suffer from the breach, but it's clear that the damage can be considerable, and therefore this is not excessive. And in both cases, Cavendish Square and Parking I, the clauses were upheld. So a liberal view, if there's a legitimate commercial interest, if it's impossible to give a precise pre-estimate, to put a number on the damage you suffer from an individual breach, then as long as it's not clearly excessive, it will be upheld. That's, I guess, the lesson to take away from those two cases. With banks and loans, usually not an issue of goodwill, but what you rightly said, the element of risk. Default signals clearly there's higher default risk, higher credit risk, and you should be compensated for that. And that's why, personally, I think the Lloyd's Finance holding is more reasonable than the Garrett holding, which you will have to take into account was not a commercial loan. This was sort of a consumer loan, and maybe the court was more strict because of that. But sort of as an idea, penalty or liquidated damages, I think, as long as you compensate for an increase in default risk, it's legitimate. In Germany, on the other hand, even penalties, and I hope you looked at these provisions on the slides beforehand, even penalty clauses, even in private settings, are legal. You can impose a penalty. That is, under German law, okay. You can ask more than just the estimate of damage. You can force someone to perform and, motivate them not to default. And if it so happens that a penalty is disproportionately large, you can complain, go to court, but that doesn't mean that you don't have a penalty. The court will reduce the disproportionately large penalty to the amount that's still barely reasonable as a penalty, not as liquidated damages. In standard form contracts, if a commercial enterprise may not use penalty clauses vis-a-vis consumers. So if you go to a bank and set out and take up a loan, you are a consumer, the bank is a commercial enterprise, no penalty clause. If you go to Kaufhof and buy something and in their contract and you have an installment payment plan and they have a penalty clause in that, invalid if it's in their standard form contract. Again, protection of consumers. On the other side, if you are a commercial entity, a commercial borrower, for example, you are expected to be able to watch out after your interests more than a consumer would be. And therefore, under this provision of the commercial code, this benefit, a disproportionately large penalty can be reduced by the court, is not available to you. That means if you, as a commercial borrower, borrow from a bank and there is a penalty clause in there and the penalty is disproportionately large, you cannot ask for a reduction of the penalty. The only time when you can strike down the penalty is if it's really, really extravagant. If it's not just disproportionately large, but extravagantly high. And there is no sort of clear borderline. So if you look at it, you start out with liquidated damages, go a little bit beyond that penalty, disproportionately large penalty, extravagant penalty. And if you reach that extravagant penalty, then it is invalid. Or if you just exploit the borrower's distress, and so the borrower is in straits and depends on it, and you force him to accept it, you exploit this unfortunate position. Question? Okay, so this is just a difference in law. Common law countries, especially England, more liberal view towards liquidated damages and penalties than they used to have, as long as there is a commercial interest underlying the clause and as long as what you have to pay in case of default or breach is not excessive, it's okay, it qualifies as liquidated damages. But if it is a penalty clause, especially if you can give a precise pre-estimate of what you're likely to suffer, and you go clearly beyond that, then it's a penalty and invalid, whereas in Germany, it would still be upheld, especially in the commercial world. And so far, when you think back of our classes on equity finance, sort of the rule was the common law countries, as long as they're not bound by European law, so the United States, more liberal, more flexible, allow more discretion, you can do whatever you want. When we looked at interest, common law countries, no limit on interest you can ask, everything up to the contract. Germany, as a sort of continental jurisdiction, statute-based, usually a more paternalistic view, you saw there are provisions on loan contracts, there is this protection by the law of general business terms. In general business terms, lots of things you can't do in order to protect the counterparty from the other commercial party of exercising too much influence and power. Why is it then that in this jurisdiction, penalties are okay, so more liberal, whereas in the UK and US, penalties are not okay? Limit on the freedom of contract in the US and UK, more freedom of contract in Germany. Why? Isn't that strange? Unexpected? Wouldn't you have expected? Yeah, freedom of contract, penalty, all right in the US and in UK. And in Germany, where the weaker party is protected, no, penalty, that's not all right. Just the other way around. Unexpected. That's why I had, one of the reasons why I had it in the materials, because from a comparative view, it's interesting. Any idea? So my proposition would be, and you can have different explanations, different idea of what the law should do. In the UK and US, especially in the US, the remedy if a party fails to perform is usually not specific performance. So if I agree to sell you something and I fail to deliver, usually you cannot sue me for specific performance, only for damages. In contrast, in Germany and other continental countries, the main remedy, the first remedy, is specific performance. If you promise to give me something and you don't perform, I can make you do it. Mm-hmm. Exception services, I can twist your arm and make you do it. Otherwise, I can just get a title from court, send the bailiff, and take away the asset. I can force you to do it. The court will give me all the declarations I need to get you the piece of real estate you sold me but don't deliver. I can force you to perform. Why is that? I think the reason is that sort of philosophically, on the continent, the idea is a promise is a promise. You as a person, the value of you as a person is partly due because you are responsible for what you do and say, and if you give your word, you should be taken by your word. That is sort of part of what makes you a person. And therefore, we take you by your word, and if you promise to do something, we make you do it if you don't do it voluntarily. Whereas the approach in the US and UK is much more commercial. The idea is, when will I not perform a contract even though I could? I sell you a car, used car for $10,000, and then I don't give you the car. Why would I not do that if I have to pay you damages? The only reason I would do it is because I found a buyer who will pay me more. And if I find someone who will pay me $15,000 for this car, then the person paying $15,000 will be happy because he got the car they want. I will be happy because I got more money than I would have gotten from you. And you eventually will also be happy because if you prove to me that the car you will now buy costs $12,000, my car was an opportunity, sort of a comparable car that you can now get because I didn't deliver is $12,000, I will pay you $2,000 in damages, so you're happy too. So commercially, everybody is better off. Sort of efficient breach of contract. If it's efficient for a party to breach a contract, the law should not keep them from doing that. And when is it efficient for someone to breach a contract? If after the breach of contract, everybody is in at least as good a position as if the contract had been performed, most likely in a better position. So in my example, the buyer who paid $15,000 is happy. I'm happy because after compensating you for your damage of $2,000, I still have $3,000 more than I would have gotten from you. So everybody happy from a commercial perspective. And that's why, if however I had a penalty clause in the contract that said if you don't deliver the car, you don't only have to compensate me for the damage, and most likely I would have to pay $2,000 more for another car that's comparable, but sort of you have to pay me $10,000 in penalty, then I would be kept from this efficient breach of contract, and this would commercially be inefficient. So efficiency versus sort of a more philosophical, person-oriented approach where you promise something, you have to do it, versus is it commercially sensible or not to allow a breach of contract. Okay, now let's move to another topic, short, compound interest. In my case here, I default with an installment, which means I don't get the installment, I don't get the interest, which means, of course, now interest is due on the $50,000, on the $10,000 I've not paid. But the question is interest also due on the foregone interest that I have not paid on time? That's the so-called compound interest. And in Germany, at least in the private setting, there is a prohibition of compound interest. So the idea is no interest should be charged on interest, with an exception for the commercial world. You can't charge compound interest in commercial transactions. In contrast, in UK and US, charging interest on interest that has not been paid on time is legal. That's not a penalty. But that's something to keep in mind if there are considerable interest payments that are outstanding. It's an issue. Can I charge interest not only on the principal but also on the interest that has not been paid on time? Now, but that's sort of a side issue. Now, covenants, that's something you find, and you know probably from other classes, in all sorts of M&A contracts, loan contracts. And I'd like to spend the last 25 or 28 minutes on covenants that are typical in loan contracts and that are interesting where you can, from a sort of corporate law perspective, as the borrower, should ask yourself, is it legal? Is it possible to enter into such agreements? Can I make such a promise? Or is this promise illegal? So covenant is just a word for a promise. By deed in writing, signed or delivered, by one party pledges that something will be done, shall be done, or shall not be done. Or promises that certain statements of fact are true. So covenant is just another word for a promise in the contract. And the promise can be all sorts of things. I'll do something, I'll pay something, I will not compete, I will give you information, and what have you. And now you have typical covenants, typical from the interest, of course, of the borrower, of the lender is to protect the interest and his business interest in receiving back the money plus interest. And you want to make sure that this is done. And therefore, one thing you're interested in is information about the financial state of the borrower. You want to monitor how the borrower is doing if you give him a large amount of money in a commercial loan. And therefore, you frequently have reporting or information covenants with information on the financial affairs of the borrowers. Covenants may include the right to receive accounts, information requested reasonably by the lender, notification of defaults, or potential or actual material litigation. So if you default on other obligations, that's a red light. And you think, wow, if he doesn't pay the other person, he will probably not pay me. I want to know to be able to take action. Material litigation, or Bayer, you want to know if there are $1 billion litigation pending. This may have serious impact on the long-term capability of the borrower to pay back the loan. Right to inspect the corporation's books and documents, I want to know firsthand. Maybe I don't believe you, maybe I want to have a look myself. And therefore I want the right to inspect your books and records. So from a lender's perspective, all perfectly understandable. From the borrower's perspective, if you're a company and we're talking about corporate finance, question, to what can you as the management of the borrower agree? So, and I mean, the easy thing is, as long as the information is publicly accessible, such as, for example, accounts that are published in Germany, for example, on the commercial register or disclosed on the website, no problem. If they're available to everyone, why not to the lender? But of course, if you're a lender, you say, that's not exactly what I'm interested in. I don't need a contractual provision that entitles me to look at stuff that I can look at on your website or in the commercial register. What I'm interested in is stuff that is not available for everyone. So accounts before they're published, information that I request, access and inspection of your books and records that are not open for inspection for everyone. And the problem is, all this stuff is potentially confidential. I mean, as directors of a company, you can't simply go and give information about your books and records and your financial situation just to anyone. sort of my proof. You're under a duty of confidentiality. If you look in the German statute, section 93, here cited, of the Stock Corporation Act. Board, as a director, shall not disclose confidential information and secrets of the company, in particular trade and business secrets. Confidential information, by definition, should be kept confidential, and your books and records, to the extent that they're not supposed to be published on the website or in the commercial register, are confidential, as is probably information that is not publicized, but that the borrower, that the lender is interested in. Can you disclose that? Is that not a violation of your duty? And you would probably have, even if it's not explicitly spelled out in the statute, similar duties in the UK and US. Directors must keep company secrets. You cannot simply disclose company secrets to outsiders. That's a violation of your duties, and you're liable for damages if you do it. So one question from a company law perspective, are you allowed to do that? Or is that covenant illegal because it would force you to violate your duty to keep company secrets confidential?
Can you ask the banks also sign a confidential agreement?
Sure, you can say you have to keep what I tell you, you have to keep confidential, but that's like with a secret. I tell you a secret if you don't pass it on. Once you do that, everybody knows. I mean, and the purpose of keeping stuff confidential would be, that's my argument now, or my question is not to tell anyone. And your argument would be, but I can tell some people. And my question would be, am I allowed as a director to tell my bank secrets that I'm not allowed to tell other people? How would I know the answer? How can I arrive at the answer? So I can sort of have a gut feeling, that must be possible, or no, that's illegal. Or I can approach this as a lawyer. As a lawyer, I'd say I would start with a duty. I'd say, okay, there's a duty of directors to keep company secrets confidential and not to disclose them. And the question would be, why? What's the purpose of that duty? What's the purpose of the duty? That's my question to you. What's the purpose of the duty to keep company secrets confidential and not to disclose them? In very general terms. Very general.
Protect business interests.
To protect, absolutely right, to protect the interest of the company. So the purpose of the duty to keep company secrets confidential is to protect the interests of the company. Which means if the interest of the company mandates that I disclose certain information to certain people, such as my bank, because otherwise I will not be able to get a loan or will not be able to get it at reasonable interest, because the bank says without this information I will not be able to assess your credit risk and to monitor your property. And maybe there are requirements of banking regulation that mandate that I have access to that information and that I get this information. So I couldn't get a loan. So if the interest of the company would be hurt rather than promoted if I kept the company secret, confidential, even vis-a-vis my bank, then it's not a violation to disclose it to the bank. Maybe if the bank signs a confidentiality agreement and says I will not pass it on, not even within the bank to other departments who don't have anything to do with the loan. So starting, you find a duty, you ask what's the purpose, and is this specific covenant a violation of the duty? And the answer is no, as long as it's in the interest of the company to disclose rather than to keep secret. And the argument would be, otherwise I can't get a loan or not at reasonable interest. Therefore, it's in the interest of the company and therefore not a violation of the duty. But I also posted something else here. Disclosure of information. Let's assume the company is a listed company, and let's assume, and that's, I think, is reasonable. The bank is mainly interested in information that is likely to have impact on the creditworthiness of the borrower. Otherwise, if it's irrelevant for your ability to pay or not to pay, it's not really interesting. So what I'm interested in is information that has impact on your ability to pay the loan. For example, defaults, material litigation, stuff that might keep you from being able to pay back. And such information, if it has impact on my ability to pay back my debts, then it's very likely to also have significant impact on the share price. If it turns out the company defaults, there is material litigation pending, then this will affect the share price. So if I'm a listed company, by definition, this would be inside information. And inside information may not be disclosed except in Europe under the market abuse regulation, except by an ad hoc disclosure, a current report in a certain manner made public to everyone, so that all investors have this access to the same information. So here we have a duty to keep certain information that may have significant impact on the share price confidential, not because it's in the interest of the company, but because we want to ensure that all market participants have access to the same information, and we want to prevent some people trading on the basis of superior information and therefore defrauding other investors who don't have that information. So if I know, for example, that the company has defaulted and material litigation is pending and that the share price is likely to go down, I as a director know, I quickly sell my shares to you. You don't know about that, you buy them at the still too high price. 2 days later the information is disclosed, the share price goes down, now you're unhappy. I'm happy, I said, wow, got rid of the shares just in time. Did I get rid of the shares in time because I was smart? No, because I had access to information which you could not possibly have known. So this is a duty to keep information secret that's not owed to the company, but that's owed sort of to the securities market. And therefore the argument disclosure to the bank is in the interest of the company would not be a justification for not complying with the duty to keep this inside information secret. Question, therefore, if I'm a listed company who has borrowed, I've gotten around this hurdle, I've jumped over this hurdle, yes, I'm not violating my duty to the company if I give all these covenants to the bank, but am I possibly violating my duty to the securities markets if I give you information, such information that has impact on the share price, and I give it to you, the bank, but not to others? And here, there is a provision in the market abuse regulation that says inside information may be passed on if it's done in the normal course of business. So there is an exemption if it's done in the normal, regular course of business of the issuer, here the borrower company, then it's okay. And here this would be the exemption on which the bank would, on which the borrower would rely. The company would say, yes, I'm disclosing this in the regular course of business because the regular course of business of a company is to take up loans from banks. And to take up loans from banks, I have to give the bank certain information. May the bank use such information for its securities trade business? Now it hears sort of the loan department hears, oh, default. Can now the person in the loan department go to the person in the securities trading department and says, first of all, get rid of all the shares that we have in that company, and secondly, tell all your good customers to get rid of those shares as well before the information leaks out and the share price drops? Answer, clearly no. You may only use the information for the purpose for which it is given, that is for the loan contract, administration of the loan, not for other purposes. That's why in banks you have to have so-called Chinese walls between the loan department and the securities trading and customer department, so that the information is used only for those purposes, because otherwise the bank and its privileged customers would be able to dump the shares on you, the unsuspecting share purchasers who 2 days later are unhappy because once the information is disclosed, the share price drops. Financial covenants. But here, by the way, disclosure of information is an issue here in the loan contracts, the covenants, but also if you have M&A, a purchase, you give you perform a due diligence, you allow a due diligence to be performed by a potential buyer. Same issue. Are you allowed as a company to disclose secrets that are potentially significant for the share price if you're a listed company, and those are the informations that potential buyers are interested in, not information that is insignificant for the share price or that's publicly available. They're interested in information that's hidden away but potentially significant for the share price. By definition, inside information and confidential information. Are you allowed as a board of the company may you as a board of the company allow such a due diligence? And you have the same question. Are you violating your duties to the company? And you must justify that by saying it's in the interest of the company that the shares are bought by this person, which is not always easy to do because in M&A it's not the company who sells shares and collects the purchase price. It's one shareholder selling shares to the other. And so you would say, why should I care if A or B is the shareholder? And if you're not interested whether A or B is the shareholder, then you have no right to give B information that's secret. So you have to make an argument, it's in the interest of the company that B buys the shares from A. For example, because B is in a position to support management's course of business and provide more funds, sort of an anchor investor who will stay with us for a long period of time and support sort of the business strategy. Therefore, it's in the interest of the company, not just in the interest of the seller. And here, disclosure, if you're a listed company, are you allowed to give access to inside information? Again, you have to have a justification for that. So financial covenants, all sorts of things, disposal of assets covenants. I want to prevent asset stripping and make sure that the borrower doesn't impair its ability to pay by disposing of valuable assets below market price. Change of business covenants. I lend to, a steel producer. I don't want to end up as the lender of a tourist travel agency. That's something we had in Germany. We had a company that started Pleusag as a steel producer and ended up as TUI, as a tourist travel company. So maybe that's a different risk. So change of business covenant, negative pledge covenant. I give you an unsecured loan, which means I'm sort of, I get what every unsecured, the percentage that every unsecured lender or every unsecured creditor gets when the company goes bankrupt. And I do that because I expect that you don't give preferential treatment to others. So I'm unhappy if I give you an unsecured loan, I don't want you to use your valuable assets as security for other creditors. Because if you do that, then the other creditors have exclusive access to these assets. And these assets are taken away out of your estate if you're insolvent. And my quota in the bankruptcy is much less than what it would be if that asset were still in there. So negative pledge. If I give you an unsecured loan only on the basis that you don't give others preferential treatment. Interesting, the pari passu clause provides the lender's claim under the loan agreement will rank on the same level with all other unsecured debt of the borrower. You find that especially in sovereign bonds, but also in commercial loans. Why? Do you need it? I mean, how would the lender's claim rank in the bankruptcy if you didn't have that clause? If you just applied bankruptcy law, how would it rank? You have a bank that gave an unsecured loan, 10 million euro. The borrower defaults and goes into bankruptcy.
Mm-hmm.
Now you bring your claim to the receiver, say here I have a claim of 10 million. how much will you get percentage-wise? Not in numbers, but will you get more or less than the other unsecured creditors? The same. All creditors of the same class are treated the same. So that's the law of bankruptcy. That's the rule of bankruptcy law. So even without that clause, you would rank on the same level as all unsecured creditors. Why you need that clause? I don't know. And once, and nobody really knows. We had a conference some years ago just on the pari passu clause with prominent lawyers from the US and England and so forth, and people who did research back to the 18th century on pari passu clause. Nobody really knows why you need that clause. There is no explanation. But, I mean, you don't get rid of it because people say, first of all, the associates find it in the documents, in the standard documents, and they don't ask. It's always there, so okay. If you ask, they say, we always had it. If we take it away, if we take it out, then the customers who are used to it say, why don't you have that clause in here? We have it in the other contracts. So because it has been introduced, it just carried on. And it has potentially, if you give me 2 minutes extra, because it's an interesting story, and a recent story, it has potentially significant negative consequences. To give you an example, a recent example, I don't know if you heard about the Argentina debt crisis. So Argentina issued lots of bonds and defaulted regularly. Argentina tends to default every 20 years or so. And 20 years ago or so, they defaulted on their bonds, said you can't pay, and they had a restructuring of the bonds. Saying, restructuring meaning every bond, so they had, I don't know, 100 different bonds outstanding, and each of the group of bondholders, 100 group of bondholders was approached, and the question, we pay you 50% if you agree to waive the other 50% or 80% plus, I don't know, accumulated interest. You get much less, but at least you get something and will be able to pay. And from the 100 bonds that were outstanding, 95 groups of bondholders agreed and said, yes, we agree to this arrangement. We'll get only, instead of $100, these were dollar bonds, we only have $20 for each $100. And we forget about the past interest as long as you pay the $20 and the interest on the $20, okay. 5 of these 100 bonds were bought by hedge funds like Elliott and Associates, and they did not agree to restructuring. They vetoed. They had a vetoing minority in the bond, in those bonds. Said no, we don't agree to the restructuring. We keep the bonds. Okay, so time passes, and Argentina wants to pay interest on the restructured bonds, on the €20 now that are left. It wants to pay interest in dollars. And now Elliott and Associate goes to the New York court and says, if you pay interest to those 95 groups of bondholders, we want all our money on the restructured bonds, meaning 100 plus accumulated interest. Why? Pari passu clause. Pari passu clause says, if you pay one group of bondholders what they are due, you have to pay the others what they are due. The restructured bonds are due interest on $20 per what used to be $100. We didn't agree to the restructuring, so what's due to us is the full amount of the old bond plus all accumulated interest. That is what pari passu means. And since Argentina, I don't know for what reason, didn't properly defend itself in the New York court, the New York judge said, yes, that's what the pari passu clause means. Pari passu means you give every creditor what the creditor is due. And if you give one group of creditors what they are due, you have to give the other group what they are due, even if the content of what they are due is different. And what the dramatic thing is that the court said, and we enjoin any financial institution to help Argentina pay in dollars to the 95 groups of bondholders their interest in dollars, as long as the others, the hedge funds, don't get their money. If you do that, you violate US law and will, I don't know, ban you from the US market, fine you, whatever. So no banking institution, clearinghouse who wanted to do dollar business could help Argentina pay its debt in dollars to those. They wanted to pay, but they couldn't. And that was the effect of the pari passu clause. And in Germany, if you saw, for example, a one-page advertisement in the newspapers of the Argentinian government saying, you know, we want to pay, we can pay, but we're not allowed to pay because of this New York judgment. All because of the pari passu clause. So probably no use, but potentially harmful impact. Standard in all loan contracts. Restriction of dividend covenants. We said in class 1, the distinction between debt and equity is creditors first, shareholders last. Means dividends may only be paid from money you don't need to pay your creditors, right? And loan agreements drafted in those common law jurisdictions where you don't have statutory capital and dividend restrictions by statute, or at least not very strict restrictions, have covenants in the loan agreement saying you may only pay dividends that must not exceed the interest payable, or they're limited to a certain amount of money or to certain balance sheet positions, or they need the approval of the creditor. So you may only pay a dividend with the approval of the bank. Is this legal? Is it possible? Is it valid? And my argument is, or why I have this, you know, legal transplants, covenants like this developed in an environment like Delaware, like the US, can possibly be not one-to-one be transposed into a company law environment like the German one, which is completely different. If you look at Delaware, you can see that whether dividends are paid to shareholders and how much dividends paid is decided by the directors. So that shareholders have no say whatever. It's the directors, and the directors can say we don't pay any dividends. So if they agree to such a covenant, they only limit their own discretion. And why should directors not be able to limit their own discretion, as they do with every transaction into which they enter? If I buy asset A, I don't have the money to buy asset B. Therefore, I exercise and limit my discretion to do things. Why should I not, in a contract, limit my own discretion? Therefore, in the US, such a contract entered into by a Delaware corporation borrower, legal. In the UK, you have the model articles for public companies, and unless you vary them, these are your articles for your public company, and they say sort of a two-step procedure. The directors propose how much dividend as a maximum could be paid, and then the shareholders decide, but the shareholders cannot go beyond what the directors recommend. So sort of dividing the decision between directors and shareholders. But even here, the directors could set the limit at 0 and say, we recommend to pay 0. And therefore, you could argue they can also limit their discretion by entering into such a covenant and saying, we'll limit or we only recommend to pay as much as agreed to by the creditor and compatible with the covenant. So still okay. In Germany, if you look at section 82, at section 58(174) of the Stock Corporation Act, it says if you have on your balance sheet, on your annual balance sheet, a position that's called balance sheet profit, then what's done with that is decided by the shareholders. So the shareholders decide about the distribution or non-distribution of balance sheet profit, and that is mandatory, cannot be varied. And even though the directors have unlimited power to represent the company, so nothing in the company's constitution limits the authority of directors to represent the company, so sort of a business partner doesn't have to look into the articles and see is the management allowed to buy a piece of real estate for 10 million euro, or are there some limits? That is irrelevant, but statutory limitation. You know, if it's in the statute that it's not the directors who decide on dividend payments, but it's the shareholders, then this is evident for everyone, and it limits the power of the company, of the directors to represent the company. So my argument would be, in such an environment, directors cannot validly limit the discretion of shareholders. They cannot say shareholders cannot pay a dividend. If there is balance sheet profit, the shareholders are free to decide. Directors must make a recommendation what to do with the profit, but shareholders are not bound by that recommendation. And therefore, you could not enforce such a covenant. And the question is, could you have the covenant and say, okay, the shareholders can decide, despite that covenant, to pay a dividend. But if they do, it's an event of default, and the creditor can terminate the contract and maybe ask for default interest. Or sort of open to debate, because it's like saying you go out on the street and somebody puts a gun to your head and says, "Give me your money." And you can say, "Well, I'm free to say no," but are you really free if you have a gun at your head? And it's pretty much like like in this case, management has agreed to this covenant, and if you could terminate the loan and ask for default interest because the covenant has been breached, are the shareholders really free to decide on a dividend distribution? In form, yes, management can say, yeah, you can do it, but then the company is ruined. So you're not really free to do it, and so it's arguable, and I haven't seen any decision that deals with it, but arguable. The point is, a covenant that's perfectly fine under this company law regime may not be fine and harmless under this company law regime. And when you see that sort of these contract terms are designed in the US and then they move over to the UK and to Germany, to the European continent, one-to-one, it doesn't always work like that. You always have to look, does this work in this company law environment? And that's why I have this example in here. Change of management covenants. Maybe you give the company an unsecured loan because you think this management is great. And once the company doesn't have the same management, then I want to terminate the loan. And you had a case like that in the materials where it basically says under this law, yes, you can have a change of management covenant and you can enforce it. What you may not do as a creditor is to threaten the company to elect someone else by saying, yeah, if you do that, then I will terminate the loan. You can use it or not use it, but you cannot use it, you may not abuse it as sort of a means to blackmail the company. Change of management covenant, also you can ask yourself, is that something for the benefit of the company or for the benefit of the management? It's also a question of conflict of interest. Is it okay for a company's management taking up a loan to say, we want a change of management covenant because this will keep us in office? Maybe you don't care as a bank, but I care, because if we have that in the loan contract, then the shareholders or the supervisory board or whoever elects the managers will be reluctant to fire us or not re-elect us because that may be very expensive. So you can ask yourself, is this really exclusively in the interest of the bank or is this in the interest of the management? Negative pledge covenant, we talked about the reason why you have a negative pledge covenant. The question is, what happens? One question is, in this wording, will not permit to exist any security on its assets. Okay, I can talk for myself as a borrower, or those of its subsidiaries. So this is taken from a standard term. Can you talk for your subsidiary companies? Can you prevent your subsidiaries to use their assets to secure loans and get better interest rates because the loan is secured? Can you do it if those subsidiaries have minority shareholders? So can you enter into such a covenant at the expense of the minority shareholders of your subsidiaries? So open to debate. And permit to exist if the subsidiaries have already created securities. Can you force them to cancel securities, terminate securities? Maybe you're not even in a position to terminate them because it's not your right as a borrower to terminate a security. So how can you really enforce this permit to exist part of the covenant, especially with a view to your subsidiaries? And in case of breach, the borrower promises not to create a security and it breaches the covenant. Can the bank invalidate the security? That would be the question. And the lesson here from these two English cases is, and the same would be true for Germany, as long as the recipient, the receiver, the beneficiary of the new security did not induce the breach of contract, it's okay, the covenant, the security is valid. But if I, as the person who wants the security that can only be established if the company breaches that covenant, if I make the company do that, If I induce the company to breach its obligation, then it's invalid. The same in Germany, you can benefit from a breach of contract from another party because it's their business whether or not they breach their contract, and then the security is valid. But if you are the one who makes the other party breach the contract, that's more than just benefiting, that's illegal. And finally, and that's important, to alert you, sorry for going a little bit over time, it's a long topic and I promise to be more on time the next session. Risk of excessive lender influence. Of course, if you look at all these covenants, the lender wants as much influence information as you can get. Because the more influence and information you have, the safer you are. Wrong. In Germany, there is a case of 1992 where the court said, you know, you have so much influence by virtue of covenants, by information, influence on management, and all sorts of things, that you have put yourself as a bank in the position as if you were a dominating shareholder. You are not a shareholder as a bank, you have no shares, but your influence and information is like that of a dominating shareholder. And if you bargain for that much influence, then we treat you as if you were a shareholder. And if you're a shareholder, as we'll see some sessions down the line, your loan may be subordinated. And that's what the bank ended up in this case. Its loan was subordinated to those of other creditors because the bank had actually bargained for too much influence. And put it so, and there is no clear borderline in that case. It's still uncertain when am I doing what I should do to protect myself and when am I crossing the line and doing too much. Because the court really didn't give guidance when the line was crossed, it's hard to tell. But it's something to keep in mind. You can do too much of a good thing in terms of covenants. And in the UK, possibly you're liable as a shadow director. If you are a person under whose instructions the directors act, because you as a creditor get so much influence, you may be liable as a shadow director. Again, a consequence of bargaining for too many covenants, too much influence. And that's it for my presentation. Thanks very much for your patience, for the overtime. Sorry for that. But I think all the topics are relevant, interesting for debt finance. I think next time is again still me before you meet the mysterious Dr. Bauer eventually. And that will be less reading. But what we'll do is, I think, voluntary subordination of secured and unsecured debt. Not that much reading, a couple of cases, and no presentation, because what we'll have to do is to look at the cases and analyze the cases. So for that session, please read the cases very carefully. Not too much, but interesting again from comparison.
就是他欠债之后，这个是准股东，他的准股东因为债权是优先。等会儿吧，我先把这个存起来啊。